Your Honor, the defense calls J.D. Lorraine to the stand. Before we begin, permission to sit up in the courtroom to make use of the response exhibit.
You may. And then state, feel free to move if you want to.
Now proceed.
You may.
Please state your name, spelling your last for the record.
Good afternoon. My name is J.D. Lorian. Lorian is spelled L-O-R-E-A-N.
What do you do for a living, Ms. Lorraine?
Well, currently I'm the owner and chief auditor for my company, Grayler Strategy Incorporated, and our job is to consult with federal, state, and local police agencies on proper undercover protocols, as well as other investigation techniques.
And what education do you have that allows you to hold that position?
Well, first I attended Johns Hopkins University, where I received my Bachelor of Science in Applied Mathematics and Statistics. Then I received my Juris Doctor from the University of Virginia School of Law, followed by my Master's of Law from Harvard Law School.
What experience do you have in the field of undercover operations?
Well, right after completing my Master's of Law, I worked in the white-collar crime division of the FBI for 25 years, both as an investigator and senior agent. And during this time, I was part of hundreds of undercover operations involving gambling, drug trafficking, insider trading, and extortion. And in the latter part of my career, I was involved in implementing the Attorney General guidelines on undercover operations and was also a witness in the congressional hearings that followed.
And what qualifications do you have in the field of undercover operations?
Well, I'm licensed to practice law in the state of Maryland and the Commonwealth of Virginia, as well in the United States District Court for the District of Columbia. And as previously noted, I am very familiar with the Attorney General guidelines on undercover operations.
Ms. Lorraine, how are you involved in today's case?
Well, I was retained for two purposes. The first is to provide an expert opinion on the Midland State Police Department's investigation that led to the arrest of Avery Bancroft on bribery charges. And the second is to provide an expert opinion about Mickey Keenan's investigation in light of our 2014 MSPD undercover guidelines audit.
And giving your expert opinion on the department, were you provided with sufficient facts and data?
Yes, I was.
What were those facts and data?
Well, all documents regarding the current bribery charges I received by a public record request through the MSPD, and from Defense Counsel, I obtained the audio files and transcripts of a recorded conversation, as well as a wiretapped conversation.
Were there any other facts or data that you relied upon?
Yes, I also relied upon and obtained the affidavits and report of Mickey Keenan, Corey Hyde, and Pat Sikorsky, as well as all email correspondences between Corey Hyde, Mickey Keenan, Avery Bancroft, and Chase Covington.
In analyzing the department, did you use reliable principles and methods?
Yes, of course.
What were those principles and methods?
Well, these principles and methods were techniques used in my fields for detecting deception, as well as completion and documentation of all witnesses and subject statements.
Did you apply the principles and methods you used in analyzing the department to the facts and data you relied upon?
Yes, I did.
Ms. Lorraine, how did you begin your investigation?
Well, I began by reviewing the recommendations that were made in Grayler Strategies' recommendation list of our 2014 audit. And from there, I was able to assess whether or not Mickey Keenan's investigation fully complied with the guidelines and practices in this field.
How did undercover operations play a role in today's case?
Well, high-priority white-collar crimes such as gambling, insider trading, drug trafficking, and extortion often require undercover work because they are consensual crimes. Now, all this simply means is that there is a willing participant on each side and no one is being forced into the crime. Now, in today's case, as bribery was suspected, Mickey Keenan was the undercover officer assigned to the case and one who implemented the strategies in order to make the arrest.
In your expert opinion, do officers in training get training on how to implement these guidelines?
Yes, in addition to training that police officers will undergo at the academy, it is also the agency's responsibility to adequately prepare their undercover agents in implementing these guidelines when conducting an undercover investigation.
And why is getting that training so important?
Well, if the undercover agent does not have the adequate training, then his entire investigation becomes very questionable in terms of reliability as well as credibility.
Ms. Lorraine, how do those guidelines play a role in today's case?
Well, of the 4 guidelines I observed, which were training of the undercover agent, authorization to conduct the undercover procedures, if entrapment was induced by the undercover agent, or if the defendant was predisposed to commit criminal activity, I found that all 4 of these guidelines were in fact violated by Officer Keenan.
Objection, Your Honor. The witness is testifying the ultimate issue as to saying that Officer Keenan violated the guideline of entrapment.
May I respond, Your Honor?
You may.
Pursuant to Rule 704A, opinion on the open issue is not always objectionable. And this witness is not saying for certain that Mickey Keenan entrapped anyone. She's simply testifying to one of the guidelines she reviewed.
Response?
Your Honor, the witness has listed 4 guidelines, one of which was entrapment, and testified that she found problems regarding to entrapment specifically in this case. And as entrapment is being offered as an affirmative defense by defense counsel, it is one of the ultimate issues at issue in today's case.
May I respond?
You may.
Your Honor, it's just problems with entrapment. Not that any entrapment did for certain occur. So it's not an opinion on the ultimate issue. There's no definitive statement here.
I'm going to overrule it. I agree with defense that she hasn't necessarily hit the ultimate issue yet, and again, it's not always objectionable, so I'm going to overrule it for now.
Ms. Lang, were you done answering that question?
Yes, those were the 4 guidelines that I outlined, and all 4 were in fact violated by Mickey Keenan as I was conducting my investigation.
What is your charge that you brought today?
Well, the chart I brought with me today highlights the 4 guidelines that I observed, as well as how Mickey Keenan violated each one.
Would you mind stepping down to show us how he failed to meet those guidelines?
Yes, absolutely.
Commissioner of all the witnesses that I make use of demonstrative. I'd like to begin with that first guideline, training. How was that involved in today's case?
Yes, well, every agency is required to document the agent's training. Now, for today's case, I found no documentation in regards to Mickey Keenan's training. In fact, the MSPD failed to record any training that Officer Keenan may have received in implementing the RAID technique and knowing how to handle situations that involve otherwise illegal activity, as well as any further training that is essential to conduct properly an undercover investigation.
To bring to the second guideline, authorization. How did the department fail to meet authorization in this case?
Well, my investigation showed that no authorization had been obtained for any undercover procedure documented or conducted by Officer Keenan.
On to entrapment, the third element. How was that involved in today's case?
Well, in my analysis of Mickey Keenan affidavit, he's very candid in the course of techniques that he uses, both to recruit Hyde as well as keep Hyde on as his informant during the case. Now, in evaluating Officer Keenan's interactions with Avery Bancroft, that too raises some serious concerns as Officer Keenan failed to properly document any ongoings of the undercover investigation, as well as any documentation in regards to not inducing criminal activity in otherwise innocent parties.
I'd now like to bring you to that fourth and final guideline, predisposition. Explain how that's involved.
Yes, well, in Keenan's affidavit, there is no character traits that shows predisposition, as well as in any other of the facts and data that I reviewed was predisposition assigned in today's case.
Thank you, Ms. Long. You may now retake your seat. Ms. Loring, were you able to come to any conclusions in today's case?
Yes, there were 2 conclusions I was able to make for today's case.
What was that first conclusion?
Well, the first one is in regards to the 4th guideline, predisposition, and that is that there was no reasonable evidence that Avery Bancroft was engaged, had engaged, or was likely to engage in a bribery scheme, or that Avery Bancroft was predisposed to engage in the bribery scheme.
Your Honor, once again, I raise my objection to the ultimate issue, as predisposition is again one of the factors that is at issue in this case in proving whether or not Avery Bancroft was entrapped, and the witness has now specifically testified that there was no evidence that Avery Bancroft was in any way predisposed to commit this crime, when in fact she has reviewed only limited materials and cannot conclusively testify in this issue.
May I respond?
So, Counselor, can you speak more as to why in this case it should be objectionable under Rule 704, because it's not necessarily automatically objectionable?
Well, Your Honor, in this case, predisposition is the central factor that we as the prosecution must prove in order to in order to disprove the affirmative defense of entrapment. And as the witness has testified that she has only reviewed affidavits and exhibits that were provided to her by defense counsel, she has never spoken to Avery Bancroft, she has never interviewed Avery Bancroft, and the resources that she relied on to form this conclusion were too limited for her to conclusively say that Avery Bancroft either was or was not predisposed to do anything at all.
Can I respond, Your Honor?
You may.
She never clearly stated that Avery Bancroft was not predisposed, simply that she found no evidence of such. And I believe opposing counsel's argument goes more towards weight rather than admissibility. Because of that, he could be happy to take that up on cross-examination.
Your Honor, may I respond?
You may.
The witness, as an expert witness in this case, is testifying directly to a mental state or condition of Avery Bancroft, that being predisposition, and the witness is offering evidence which she posits is conclusively saying that Avery Bancroft was not predisposed. However, she does not have sufficient resources or she has not conducted sufficient research to make this conclusion.
Can I respond, Your Honor?
So are you arguing that it falls under 704B?
Yes, Your Honor.
Do you have a response to that?
Yes, Your Honor, this witness is simply coming to a conclusion based on what she reviewed. And to Rule 703, this witness is allowed to testify to a conclusion she made based on the evidence she reviewed. And she's simply stating not that there was any, for a certain predisposition, just that she found no evidence of it.
Okay. So 704B only goes to the actual defendant's mental state. I'm going to sustain your objection now. If you could limit that and have her say exactly what you said, that it was only based on the evidence, so that we're just embracing the ultimate issue, then you can go ahead and try that again.
Yes, Your Honor.
Your Honor, may I move to strike the testimony preceding the
It
objection?
will be strict.
Thank you.
Ms. Lorraine, did you come to any conclusions based on that fourth element you reviewed, based on the evidence that you reviewed?
Yes, so of the elements I reviewed, which was the affidavit of Mickey Keenan and Corey Hyde, as well as all email correspondences, in those elements, I found no reasonable indication that Avery Bancroft was predisposed to commit this bribery scheme.
Did you find any conclusions based on the other three guidelines?
Yes, that is my second conclusion, in which, due to the serious violations of the first three guidelines of training, authorization, as well as the course of techniques, I was able to conclude that the entire bribery scheme was thought up and implemented by Officer Keenan.
Objection, Your Honor. Once again, the witness is testifying to an issue that she does not have sufficient personal knowledge or evidence to make a conclusion of as to what Mickey Keenan thought. She's saying that the entire bribery scheme was thought up by Mickey Keenan, and she has only reviewed affidavits and exhibits provided to her by defense counsel and never met Mickey Keenan.
So you're objecting to improper opinion?
Your Honor, I'm objecting to improper opinion and lack of personal knowledge on it.
Ms. Wagner,
You may.
one of the affidavits that this witness reviewed was Mickey Keenan's, and because of that, she's able to come to an expert conclusion about Mickey Keenan's mindset pursuant to 703.
Your Honor, may I respond?
You may.
The witness merely reviewed Mickey Keenan's affidavit and only reviewed what Mickey Keenan chose to write in his or her affidavit. And the witness cannot conclusively say that Mickey Keenan thought up the bribery scheme. She can only say what she read and what she didn't read in the affidavit and cannot form her own opinions regarding Mickey Keenan's thoughts.
Ms. Wagner?
You may.
An expert witness can come to their own conclusions based on what they review, and because of that, pursuant to Rule 703, she's allowed to testify to that opinion.
Your Honor, may I respond to that point?
No, I'm going to overrule it now. I think we've established enough foundation that she's merely basing this off the affidavit, and it'll be noted for the jury that that's all she had in order to come to that conclusion.
Yes, sir.
I want to ask my question. What conclusions did you come to based on those other three guidelines?
Yes, of the other three guidelines and the serious violations in each and every one, pursuant to the evidence that in affidavits that I reviewed, I was able to conclude that the entire bribery scheme was thought up and implemented by Officer Keenan.
No further questions.